international law, but more recently, due to her involvement in our project on how the judiciary handles anti-Semitism, also on language, arts, and anti-Semitism. So we have a whole combination of perspectives, which we are very happy to follow. You the floor. Thank you.
Thank you very much, Professor Maron, for the kind introduction. I'm really, really happy to be here today. And yeah, thanks a lot. In the next following 50 to 60 minutes, I'm going to concentrate on the judicial handling of so-called allegations of anti-Semitism in the context of injunctions. So to make a link to the Chase lecture series, Arguing Violence, Making Peace, my talk is mainly about violence with language and through language today and the state's handling of it. But first of all, I would like just shortly to introduce the project. As Professor Maron already pointed it out, the research results which I'm going to present today are conducted as part of the research project as Struggling for Justice, Anti-Semitism as a Legal Challenge. It's, as Professor Maron pointed out, funded by the BMBF and based at the Justus Liebig University, led by Professor Maron. Other partners of that project are the Humboldt University Heidelberg, the Moses Mendelssohn Centrum for European Jewish Studies, Potsdam, and the Bundesverband RIAS, Recherche- und Informationsstelle Antisemitismus, civil society monitoring organization. And actually, as this merge of institutions shows, Ars Just is an interdisciplinary project. By taking into account the perspective of those affected and the findings of anti-Semitism research, we examine how courts and public prosecutors' offices deal with anti-Semitism. In order to answer these questions, comprehensive and systematic inventories of judicial practices are being conducted. And Ars Just is one of a total of 10 collaborative projects of the Research Network on Antisemitism in the 21st century. And all 10 projects have been investigating the causes and backgrounds of current manifestations of anti-Semitism. You can see it here on the slide, and you can find it on the homepage as well. And more information about our project as well, you can find on our homepage. As part of this project, my colleague Nina Keller-Kemmerer, who can't be here today, and we examined how we examined court decisions in connection with allegations of anti-Semitism. And that is where I now turn to the actual content of my presentation today, which has the title Allegations of Anti-Semitism in Legal Discourse in Germany, the Normalization of Anti-Jewish Language. Anti-Jewish resentment is widespread in Germany and can be found in various forms in all levels of society, making anti-Semitism an everyday problem for Jews living in Germany, and even today, almost 80 years after the Holocaust. So there is no question that it is a central task for every democracy to counteract all forms of hostility towards Jews. And the prerequisite for this, however, is that the phenomenon of anti-Semitism is recognized, understood, and addressed in its complexity, in its and its dynamics. And I quote, "Open discourse on hidden anti-Semitic tendencies in today's society, especially against the backdrop of German history, is central to this, as the Nuremberg Higher Regional Court rightly emphasized in the case of the injunction action brought up by the singer Say Benedou in 2019. However, and that's the point of my talk today, the courts do not encourage this open discourse of everyday and omnipresent hostility towards Jews, as I'm going to show. On the contrary, the analysis of the judicial discourse in cases of accusations of anti-Semitism show that an open discourse on current manifestations of anti-Semitism is not made possible, but rather it is prevented. A non-thematization can be seen which paradoxically is built on the argument of the German past and the inescapable connection between anti-Semitism and the Shoah. So this leads to a normalization of post-Nazi anti-Semitism. To show this, my presentation is divided into 3 parts. In the first part, I will trace the very well-researched public discourse on anti-Semitism in Germany after World War II, with a particular focus on the end of the 1990s and the 2000s, because at the turn of the millennium, a process of rehabilitating anti-Semitic resentment emerged, and that was characterized by the pattern of perpetrator-victim reversal, Täter-Opfer-Umkehr, which is characteristic for post-Shoah anti-Semitism. In the second part, I will show, based on the analysis of court proceedings in injunctions against allegations of anti-Semitism, that this public discourse on anti-Semitism is also reflected in the proceedings, so in the judgments we analyzed. First of all, in the statement of grounds, and with some delay also in the patterns of judicial argumentation. So I will look at the judicial discourse in my second part. And in the third part and last part, I will show how this discourse, and thus in particular the knowledge about anti-Semitism, has a particular impact on both the legal dogmatics and the outcome of the decision, and this reinforces society's blindness to current manifestations of anti-Semitism. Today, openly articulated anti-Semitism is socially frowned upon insofar as it comes across in the thundering unambiguity of National Socialist racial ideology. So apart from obvious neo-Nazi groups, so the hardcore of anti-Semites, no one in the public eye wants to be accused of anti-Semitism. Such a public and moral taboo on anti-Semitism had not always existed and has been broken time and again. So, for example, in the 19th and early 20th century, the confession of anti-Semitism was part of everyday political life, and it was like a cultural code. So it had an identity-forming function and was generally accepted. And even, and that's actually shocking, and even immediately after the end of the National Socialism, so after World War II, anti-Semitic resentment was openly expressed by a large part of the German non-Jewish population after a really very short period of consternation. Surveys commissioned by the Allied military government showed that the majority of the German population continued to harbor racist and anti-Semitic resentment. So the first survey, conducted in 1946 in the American occupation zone, revealed that 39% of the population could be classified as anti-Semites. And in 1949, a quarter of the population in Germany still described themselves as anti-Semites, with the figure rising to 33% in 1952. At the same time, the Holocaust and the National Socialist continuities within the Federal Republic states institution were largely ignored in public debates. The sociologist Werner Bergmann aptly described this as an early final tendency, frühe Schlussstrich-Tendenz, already between 1949 and 1952. So only very slowly did a public consensus of anti-Semitism developed, whereby any form of hostilities towards Jews was publicly discredited. However, and that's important, this was not associated with a self-reflective reprisal within German society. So neither at private nor institutional level were the own entanglements with National Socialism explored or critically questioned. So anti-Semitic resentment was thus merely deprived of the opportunity to public expression and was shifted to the private and family sphere or to semi-public spaces such as a Stammtisch, for example. So this resulted in the development of a communication latency and a Kommunikationslatenz of anti-Semitism, and with it a discrepancy between anti-Semitic communication in the political media, anti-Semitic communication in the political media and the public discourse on the one hand, and anti-Semitic attitudes in large sections of German population. But this public consensus did not last long. As early as the 1990s, this taboo on the public reproduction of anti-Semitism was successively broken by a longing for the Schlussstrich, for the final stroke, And this narrative of a Schlussstrich was that Germany should finally free itself from the burden of guilt and become a normal nation again. The anti-Semitic resentments that had been repressed into the private sphere emerged from latency into a form, in the form of a post-Shoah anti-Semitism, or sometimes called post-Holocaust anti-Semitism, or called secondary anti-Semitism, but I prefer post-Shoah anti-Semitism. The willingness to call it, sorry, I prefer to call it post-Shoah anti-Semitism. The willingness to express anti-Semitism became normalized, provided it did not take the form of National Socialist ideology, as I pointed out at the beginning. So, and with it, a new German victim discourse emerged, which to this day is characterized by striving for normality and a rejection of guilt and responsibility. A central event in this erosion of boundaries, the Erosion der Grenzziehung, as the political scientist Lars Rehnsmann describes it, was Martin Walser's speech delivered upon his acceptance of the Peace Prize of the German book trade in the Paulskirche in Frankfurt am Main on October 11th, 1998. In this speech, this mentality of drawing a line is clearly recognizable. Walser staged himself as courageous pioneer and taboo breaker who, I quote, trembling with boldness or audacity, described Auschwitz as a means of intimidation, Einschüchterungsmittel, also Auschwitz als Einschüchterungsmittel, and moral cudgel, Moralkeule. You can see an excerpt from the speech here, translated into English on the slide. But I will not read it out. I just trembling with boldness. Auschwitz is not suitable for becoming a routine threat, a means of intimidation that can be used at any time, a moral cudgel. You can read it here. It is the permanent presentation of the Holocaust that convinces German society that it is a normal people, Walser said. But, and I quote again, what suspicion do you fall into when you say that the Germans are now completely normal people, a completely normal society, asks Walser, leaving unspoken which suspicion he is referring to. However, like so much of his speech, this does not go unnoticed. Walser does not use the word Schlussstrich either. Despite this, or precisely perhaps because of this, Walser's speech gave new impetus to the public debate about the end of confrontation with the Nazi past and shifted the boundaries of what could be said in public. So the break with the taboo was thus not open and loud, but quiet and subtle, and is comparable to the strategies of today's right-wing populism. But I have to add, Walser's speech in the Paulskirche in Frankfurt am Main was not the first provocative attempt to push the boundaries. You had that attempt even before. You can find many examples, such as, for example, the so-called Bitburg controversy, 1985, as well as the first historian dispute, also 1985, the planned performance of the play Der Müll, die Stadt und der Tod by Rainer Werner Fassbinder in Frankfurt am Main as well, 1985. Last but not least, the often forgotten Goebbels-Gorbachev comparison by Helmut Kohl, 1986. So the aim of these debates were always to finally draw a line under the past and, I quote, to step out of the shadow of the Third Reich and Adolf Hitler's haze and become a normal nation again, as CSU politician Franz Josef Strauss put it in 1986. However, and that's the difference between those debates and Walser's speech in the Paulskirche, while before there were a huge public outcry in most of these cases, the vast majority of people did not object to Walser's speech in the Paulskirche. That was the difference at the end of the 1990s. So on the contrary, Walser received much applause. Only the then president of the Central Council of Jews, Ignaz Bubis, as well as his wife and some other people refused to agree to the speech. So this clearly shows the reversal of the pressure to justify oneself, which gradually took hold at the end of the 1990s. So increasingly, it was no longer those who made anti-Semitic statements who had to justify themselves, but those who voiced anti-Semitic resentment. So in the case of the Paulskirchen speech, it was not so much Walser's words that were scandalized and brought into focus. Rather, it was the reaction of Bubis who described Walser's speech as geistige Brandstiftung, intellectual arson, and latent antisemitism, which were declared to be the actual cause of that scandal. So you can see the reversal of Rechtfertigungsdruck, a pressure to justify. This process of rehabilitating anti-Semitism in Germany in the form of post-Shoah anti-Semitism was exacerbated in 2002 by two further events. The Jürgen Möllermann affair, I'm sure some of you will remember. I will not go deeper into that due to time reasons. But the second one, the other event was Walser's book, Death of a Critic. So it was again Walser who not only encouraged the final stroke mentality, but also the public acceptance of anti-Semitic thought patterns. In his book, Death of a Critic, he personally settled accounts with the German Jewish critic Marcel Reich-Ranitzky and unequivocally reproduced anti-Semitic resentments. Walser himself had sent the manuscript to the Frankfurter Allgemeine Zeitung, the FAZ, with a request to reprint. The editor of the FAZ, Frank Schirmacher, who had held the laudatory speech for the author in the Paulskirche, rejected the advanced publication in an open letter in May 2002 in the Frankfurter Allgemeine Zeitung, and described the work as an execution and a document of hatred. He criticized the novel as a murder fantasy of a Jew and very clearly and unambiguously emphasized the, I quote, repertoire of anti-Semitic cliché that could not be overlooked. You can see an outtake of Schirmacher's public letter translated into English here at the slide. I will not go into detail into this letter because the important point for my talk is another one. Important for my talk is that from this point onwards, terms such as Generalbass Antisemitismus, general bass antisemitism, censorship authority, censorship feuilleton war characterize the public discourse surrounding Walser's work. The accusation of antisemitism as an act to be condemned thus increasingly became the focus of public discourse, while antisemitism itself received less and less attention. And again, which I already pointed out, the pressure to justify was reversed. It was no longer the person who entered the public discourse with anti-Semitic statements who had to justify himself, but the person who criticized this anti-Semitism, and even more, those who were criticized for their anti-Semitic statements even felt entitled to take legal action against this criticism. So, and that's important here, Walser, for example, considered taking legal action against Schirmacher, and that is where I actually mark the turning point in the debate. Because it's exactly during this time when we can find the first documented court decision in a case of an action for injunction against allegation of anti-Semitism. But the interesting point is it was not Walser, as far as we can see. Walser in May 2002 merely threatened legal action against Schirmacher's statement, but did not follow through. Who did follow through was Jamal Carsley, at that time North Rhine-Westphalian member of the state parliament and the Green Party. And in March 2002, he described the actions of the Israeli army against the Palestinians as Nazi method in a press release. So there it says, due to their own history, Germans in particular should be expected to be particularly sensitive when an innocent people is defensively exposed to the Nazi method of ruthless military power. Although Carsley apologized for the Nazi comparison, he explained shortly afterwards in an interview with the far-right newspaper Junge Freiheit that criticism of Israel was hardly possible in Germany due to the fear of the influence, I cite, influence of the Zionist lobby, and described German politics as cowardly. However, this cowardice was what he said was understandable and was precisely due to the great influence of the lobby, he pointed out. It, I quote again, holds most of the media power in the world and can bring down any personality, no matter how important. So thus he reproduced anti-Semitic conspiracy myths. After Carsley's statement were criticized within the Green Party, Carsley resigned from the party and was accepted as member of the FDP, the Free Democratic Party, on the same day. And this, in turn, led to fierce criticism from the ranks of the FDP. Michel Friedman, deputy chairman of the Central Council of Jews at that time, attributed Carsley's choice of words to the politics of National Socialism and criticized him as anti-Semite. Sorry. In ZDF, in television, 2002, May 2002, he said Jamal Carsley, criticized the Jewish Zionist lobby and its global influence. And here we really are in the middle of the Third Reich. You can accuse the leadership of the party, of the FDP, of any anti-Semitism, but anyone who tolerates anti-Semitism in their party will be held responsible. We are not the Israeli ambassadors, we are German citizens, we are Jews, and if you find out every day that you are held responsible for everything good and bad that happens in Israel, then this also clearly shows that we are apparently still not seen as Germans, but are reduced to actually belonging to Israel as people of Jewish faith. So that was what Friedman responded. And then Jamal Carsley received support from Jürgen Möllermann, who attacked Michel Friedman and made him responsible for anti-Semitism in Germany. And I quote again, "I fear that there is hardly anyone who gives more support to the anti-Semites who exist in Germany and whom we must fight than Mr. Sharon and, in Germany, Mr. Friedman with his intolerant, hateful manners." If one now compares the statements of Walser, Möllermann, and Jamal Carsley, the pattern of perpetrator-victim reversal can be recognized in all of them. A pattern that is fundamental to post-Shoah anti-Semitism, because the Shoah represents a legitimizing problem for all forms of hostility towards Jews after 1945. The Holocaust must be denied, derealized, trivialized, so that anti-Semites can once again present themselves as victims of Jewish deeds. However, denying the Holocaust was and is, at least in supposedly intellectual circles, not an adequate means of legitimization for, and I quote Walser again, "No serious person denies Auschwitz. No person who is still capable of reasoning is fiddling with the atrocities of Auschwitz." Walser emphasized this in his Pauskirchen speech. In contrast, the perpetrator-victim reversal comes across more skillfully and inconspicuously in the form of the demand to draw a line. So the demand to draw a line on the Nazi past implies that enough has finally been atoned for and that all responsibility for Nazi rules has been overcome. So as a result, any accusation relating to the National Social past are dismissed as unjustified, and the Germans are stylized as victims of unjustified accusation. At the same time, and that's important, a latently aggressive attitude resonates towards those who speak out against that Schlussstrich mentality and keeping those who keeping memories alive. And in Walser's imagination, someone has to wield the Moralkeule of Auschwitz. Jürgen Möllermann, on the other hand, is blunt. According to him, Ariel Sharon and Michel Friedman, and therefore the Jews themselves are to blame for anti-Semitism in Germany. It should be clear that this is a case of perpetrator-victim reversal. Another symptom of the perpetrator-victim reversal is that from the end of the 1990s, the so-called accusation of anti-Semitism became the focus of public debate, while anti-Semitic resentment itself was pushed into the background. It were not Friedman or Ariel Sharon who defended themselves with an injunction against the statements of Möllermann or Carsley. Rather, it was Carsley who filed a lawsuit against Friedman's statement with the Düsseldorf Regional Court. The subsequent judgment of the Düsseldorf Regional Court is the first documented injunction against accusations of anti-Semitism, so directly 2003. So, which again highlights the discursive upheaval during this time. It shows how powerful the discourse of guilt reversal had become at the beginning of the new millennium, so powerful that people who made anti-Semitic statements were convinced of their legitimacy, of their arguments, and their conviction that at the same time did they not fear any serious negative consequences. It is now interesting to look at the plaintiff's arguments here. So the grounds of the lawsuits, Carsley's lawsuits. It's not only the fact that a lawsuit was filed against allegations of anti-Semitism, but also the argumentation structure of the plaintiffs themselves reflects the pattern of perpetrator-victim reversal. So Jamal Carsley, for example, states in the complaint that the accusation are a deliberately defamatory statement of opinion that violates his general right of personality and honor. In Germany, in particular, he states the accusation of anti-Semitism is particularly suitable to have a despairing effect because the accusation is always accompanied by the insinuation of the ideology of National Socialism, Carsley argued. He said anyone who publicly associates another person with National Socialism and its ideas is aware of the historical significance of such a qualification, which in Germany can only be understood as negative and discrediting. And it's precisely these arguments that can be found in all statements of grounds in the decision examined. Three central argument strategy can be identified in this statement of grounds. Firstly, the unreflected invocation of the general right of personality by the person who has voluntarily entered the public discourse with a controversial opinion and thus given rise to the reaction at issue. Secondly, the use of German past to justify the reproduction of anti-Semitism and thus the argumentative use of the Holocaust to emphasize the seriousness of the accusation. And thirdly, the reduction of anti-Semitism to the National Socialist racial ideology, whereby the accusation of anti-Semitism is fended off and everyday hostility towards Jews is thus suppressed. So the memory of the Shoah is thus used to legitimize anti-Semitic resentment. These mechanisms of defense against criticism of anti-Semitism are paradigmatic for the justification of injunctions against accusations of anti-Semitism and can be found in different forms in each of the analyzed court proceedings since 2003, so since the first judgment can be found. The plaintiffs repeatedly emphasize that, I quote, extraordinary intense stigmatization and discrediting effects of the allegations of anti-Semitism. And this becomes particularly clear in the grounds for the injunction action brought by the singer Naidu. I therefore take this example to illustrate this point. In this very well-known case, an injunction was sought against a statement made by a speaker of the Amadeo Antonio Stiftung, a Referentin der Amadeo Antonio Stiftung. And she was asked during a lecture on Reichsbürger, self-administrators and sovereignists in July 2017 by the audience about her assessment of Naidu. And she responded as follows: I would put him with the sovereignist with one foot in the Reichsbürger. He is anti-Semitic, but I don't think I'm allowed to say that openly because he likes to sue, but that is structurally verifiable. The speaker bases her opinion on, among other things, the lyrics of various songs by Xavier Naidu and Söhne Mannheims, which in her opinion reflect anti-Semitic stereotypes and worldviews. For example, in his song Raus aus dem Reichstag, Get Out of the Reichstag, for example, you can find this lyric in which he sings about Baron Totschildt, Schmocks, etc. You can read it, I will not read it aloud. did indeed take legal action and was initially successful. The Regensburg Regional Court prohibited the speaker from calling Naidu an anti-Semite. The singer justified his injunction by stating that the accusation of anti-Semitism, and I quote, also expresses that the person attacks people solely because of their religious affiliation and makes them responsible for the evil of the world, and also shares, and that's the important point here, also shares the conviction of those who led to the murder of the 6 million Jews, which is why the accusation is particularly serious. This clearly shows the instrumentalization of the past to defend anti-Semitic resentments. Building on this, the justification for injunctions often emphasizes that only those who reproduce National Socialist idea and deny or glorify Holocaust can be anti-Semitic. I will now turn to the second part of my presentation, which deals with the legal discourse. So the question is, how did the courts deal with the so-called allegations of anti-Semitism? In the parts before, I traced first in my first part, I traced first the public discourse as well as the pattern of argumentation of the plaintiffs, and turn now to the argumentations of the courts. Therefore, I will first discuss the decision in the Carsley case, as this is a special case and actually was the first case we could actually find in 2003. Only in this case, and this is interesting, did a court manage to draw a differentiated picture of anti-Semitism. But the discursive break, which I outlined at the beginning in relation to the public discourse, follows in all the subsequent judgments. And in fact, it's only the Regional Court of Düsseldorf in the Carsley case which did not grant the injunction. In all the other cases that follow, the injunctions were granted and thus the criticism of anti-Semitism prohibited. While the grounds for the lawsuit follow the pattern of argumentation of the Schlussstrichenzählung mentality, as I showed before, the court in the Carsley decision paints a more differentiated picture of anti-Semitism. So it's true that the Regional Court of Düsseldorf, judged the statement that Carsley attracted attention through anti-Semitic statements. So that was the statement at issue to be, and I cite, sharp attack on the general right of personality, which was capable of despairing him before third parties. However, and that's an important point here, no reference is made to the particular effect of such criticism due to German history. And furthermore, the phenomenon of anti-Semitism is also not reduced solely to National Socialist racial ideology. On the contrary, in its reasons for its decisions, the Regional Court refers to the long history of hostility towards Jews and the various manifestations of anti-Semitism, as you can see on the slide here. I will not read everything aloud, but the beginning also shows how differentiated the court is here. The accusation of anti-Semitism is not synonymous with the insinuations that someone is a Nazi, uses Nazi methods, or has a fascist ideology. Anti-Semitism is a phenomenon that is much older than Nazism and fascist ideology. So the court, therefore, does in 2003, for the first decision we could find, does not follow the plaintiff's preliminary argumentation, the pattern of perpetrator-victim reversal. Rather, the court's discourse is characterized by a differentiated understanding of anti-Semitism. Instead of using the past to legitimize the allegations of anti-Semitism as particularly serious, the court managed to open up the discourse and to allow criticism of anti-Semitic resentment. But, as I already mentioned, the discursal break follows with some delay in all following decisions. And if I remember right, the next one we could find 2006. The judicial discourse falls into the pattern of perpetrator-victim reversal using the German past to legitimize anti-Semitic resentments, as I'm going to show. So since then, it is repeatedly emphasized how serious the accusation of anti-Semitism is against the backdrop of German history. For example, the grounds of a 2008 injunction state that the accusation of anti-Semitism is, I quote, particularly serious and more likely than almost any other accusation to disparage the person associated with this attitude in the eyes of the public. This is justified by the horrific consequences that anti-Semitism has brought about in Germany particularly. It goes on to say, anti-Semitism was the ideological basis for the genocide of Jews committed by Germans. It is this dimension that makes it seems particularly dishonorable to be accused of the mindset that made this possible. The background of this legal dispute was the so-called anti-Semitism dispute between the publicist Henrik Broder, and the publicist Evelyn Hecht-Galinski. Galinski had made several public statements critical of Israel's policy. Among other things, she had spoken of Israeli Jewish lobby and compared the situation in Ramallah with that of the Warsaw Ghetto. So thus she was reproducing classic anti-Semitic conspiracy myths and Holocaust relativization. In an internet letter to the VDR director, Broder then criticized Hecht-Galinski's statement as anti-Semitic and anti-Zionist statement, against which Hecht-Galinski initially successfully brought an action for injunction before the Cologne Regional Court. The court then prohibited Broder from making the statement in question, and thus the criticism of anti-Semitism, emphasizing the seriousness of the accusation. According to the court, the focus of the statement was not to substantive debate on that matter, but the defamation of the plaintiff in the injunction. So the defamation of Hecht-Galinski. In the appeal proceedings, however, the Cologne Higher Regional Court overturned that judgment and found that the statement in dispute, so the statement was that her speciality of a certain person of her was anti-Semitic and anti-Zionist statements, was a permissible expression of opinion. So the Higher Regional Court of Cologne overturned the judgment. And now the interesting point is that although the judgment of the Cologne Regional Court was overturned, in the second instance, the judicial discourse remained unaffected. On the contrary, the regional court's finding that the so-called accusation of anti-Semitism was particularly serious, and I quote, against the backdrop of German history, has been received in all first instances and sometimes even second instances court decisions against criticism of anti-Semitism since today. In some cases, even verbatim with reference to that decision. Just to give you an example, in 2014, the Munich Regional Court also formulated in its reasons for its decisions in the so-called Elsässer Dittfurt trial, formulated like this. Because the term, and you find it again here, expresses that the person shares the beliefs that led to the murder of 6 million Jews. It is this narrative that runs like a red thread through the court decisions examined. It's repeatedly stated that the use of the term anti-Semite cannot be understood in Germany without the reference to German history. So anti-Semitism is thus reduced to the ideology of National Socialism and therefore racist anti-Semitism. So all other forms are ignored. I will now turn to part 3. In that following and final section of my presentation, I will now show that the above traced discourse on anti-Semitism decisively determines the results of the judgments. So the narrow understanding of anti-Semitism is reflected above all in 2 dogmatic points of examinations. Firstly, in the context of interpretation, of the act of interpreting the statement in dispute, and secondly, in the context of weighing up the conflicting fundamental rights position, so in the balancing of the fundamental rights position. And on this balancing, on the latter, I will concentrate in the following. In cases of civil injunctions against statements critical of anti-Semitism, the courts must examine whether the person affected by the statement has a so-called injunctive relief against the person making the statement. And the prerequisite
for this is firstly a violation of the general right of privacy, das allgemeine Persönlichkeitsrecht. This violation must also be unlawful, since the general right of privacy is a framework right, so the violation of legal interest does not already indicate unlawfulness. In cases of allegations of antisemitism, therefore, the assessment therefore focuses on balancing the severity of the impairment of the right of privacy caused by the statement on the one hand and the loss of freedom of expression, also die Einbuße an Meinungsäußerungsfreiheit caused by its prohibition on the other hand. According to the requirements of the Bundesverfassungsgericht, the Federal Constitutional Court, the conflicting constitutional protection interests must be balanced by practical concordance in such a way that both fundamental rights have the greatest possible effect. And it has established over years criteria for weighting up freedom, balancing up freedom of expression on the one hand and the allgemeine Persönlichkeitsrecht on the other hand. But analyzing the court's dogmatic approach to injunctive relief, two central aspects have emerged. First, no clear dogmatic distinction is made between determination of the impairment of the general right of privacy on the one hand and the question of the intensity of this impairment on the other hand. So while the question of the intensity of the impairment is part of the balancing, die Abwägung, ist eben Teil der Abwägung, it is precisely this separation of points, of audit points, that is not observed in the majority of the decisions examined. Instead, the courts generally emphasize the seriousness of the accusation of antisemitism when determining the violation of the law. So what follows is this structure of the court's argumentation has the consequence that the particular seriousness of the accusation of anti-Semitism is brought to the fore right at the beginning of the decision, and thus gives him a special weighting of the fundamental rights positioning already in the introduction. So the outcome of the decision is already anticipated here at the beginning. And the second point is, on the other hand, the lack of separation between identification of impairment of personal rights on the one hand and weighing of the conflicting fundamental rights on the other hand means that the intensity of the interference and thus the pillaring effect, as the courts call it, is mentioned at least in two places of the decision. This also anticipates or at least significantly influences the outcome of this decision. So they always repeat this they always repeat that point and not bring it only once. The examination of the court decisions also revealed, and that's the second point, that the courts did not carry out a thorough balancing exercise in any of the cases examined. In particular, important weighting criteria, also Abwägungskriterien, were regularly not included in the balancing exercise. So not all possible weighting criteria. In cases of injunctions against allegations of antisemitism, especially four criteria are particularly relevant. On the side of the general personal right, auf der Seite des allgemeinen Persönlichkeitsrechts, the severity of the impairment of the right of privacy is an important criterion, as I already mentioned. This is of great importance in the overall balancing of the interest, because the greater the interference with the right to privacy is, the more likely it is that the balancing of interests will be in favor of the injured person. For the right of the freedom of expression, on the other hand, it plays a central role whether and to what extent the statement at issue is a contribution that relates to a topic of general social interest. So this is because a permanent and open exchange of opinions on all public matters is essential for the functioning of democracy, which is why the criterion must be included in the assessment. In addition, the prior behavior of the person affected by that statement of issue is also relevant for the right of freedom of expression. For example, the protection afforded
by the general right of privacy may be reduced if the person concerned has entered the public discourse himself or herself by making a statement. And under certain circumstances, this can also lead to a right to strike back, Recht auf Gegenschlag. The analysis of the judgments reveal the following. As already shown above, the majority of the court's decisions do not lack an emphasis on the particular intensity of the impairment of the general right of privacy. Das wird immer wiederholt in diesen ganzen Urteilen, außer dem ersten sozusagen. It is repeatedly emphasized that it is precisely the background of German history that must be given special consideration in the balancing of interest. In this logic of the court's reasoning, the horrific consequences that anti-Semitism has brought about in Germany in particular means that statements critical of anti-Semitism are only permissible if the criticized anti-Semitism comes across openly and bluntly in national social jargon. This gives the general right of privacy such a great weight in cases of accusations of antisemitism that freedom of expression must always take a backseat when it comes to criticism of current manifestations of antisemitism. Second, while on the side of the general right of privacy, the strength and the intensity of the impairment of the right of privacy plays a central role in the weighing of the fundamental rights positions, it is of essential importance for the right to freedom of expression, whether and to what extent the statement at issue is, and I quote, questionable that substantially affects the public sphere. The guarantee of an open discourse is an expression of democratic societies. In the judgment analyzed, this central constitutional principle is only marginally, if at all, included in the fundamental rights balancing between freedom of expression and personal rights. Rather, the analysis shows that most of the judgments did not address this balancing criterion. To show you one example, in the decision of the Munich Regional Court in the Elsässer Dittfurt case, it remains completely unmentioned that the thematization of current anti-Semitic resentments represents an important debate for society that is of general interest. The politician Jutta Dittfurt had described the journalist Elsässer as fervent Antisemit, glühender Antisemit. Elsässer had repeatedly made public statements with anti-Semitic conspiracies. In 2014, for example, he publicly criticized the public financial oligarchy as follows. I will not read it out right now. The interesting point is that instead of pointing out that the public discourse on current manifestations of anti-Semitism is an important topic for society and that Elsässer himself has also entered the discourse with critical statements, the court focuses primarily on examining whether there is sufficient evidence to justify the labeling of Elsässer as glühender Antisemit. And even more, the court even goes on to defend Elsässer and emphasizes that, and I quote, such criticism, regardless of whether it is accurate or not, must be possible and does not constitute a sufficient connecting fact for a designation of the critic as an ardent and thus passionate antisemit. So one needs to highlight here that what was meant here with such criticism was Elsässer's criticism of the international financial oligarchy, which he had publicly expressed in 2014. And indeed, it's not possible to prohibit such expression by the state. This is precisely part of the freedom of expression. However, criticism of such statements need to be possible in public, but it is such open discourse that is prevented here by the regional court. What remains at the end is the anti-Semitic conspiracy myth. I will now turn to two following balancing criteria before I come to the conclusion. Another central criterion on the context of balancing up freedom of expression and allgemeines Persönlichkeitsrecht is the previous conduct of the person affected by the statement at issue. So for the more a person places himself in the focus of publicity, the more his need for protection decreases.
as the Bundesverfassungsgericht pointed out. So those who voluntarily submit to the conditions of the battle of opinions, that means who consciously express themselves publicly, also partially leave the protection area of their allgemeines Persönlichkeitsrecht. Voluntarily participation in the battle of opinions therefore means that harsh criticism must also be accepted. The other side of this criterion is the right to strike back, das Recht zum Gegenschlag, as I pointed out, according to which the person who has given rise to questionable judgments in public and thus provokes criticism must also accept a harsh reaction, even if this diminishes his or her reputation. This right to strike back does not require an immediate proceeding insult, nor does the person criticizing have to have been attacked directly by the person addressed. So this means, for example, concerning the case Say When I Do, that the statement made by the reference from the Amadeo Antonio Foundation, that the speech should also fall under the right to strike back. But just like the criterions above mentioned, the criterions these criterions as well remain unmentioned in the majority of the judgments, or they are rejected, and this rejection is justified by the intensity of the violation. The right to strike back, for example, is only mentioned in one judgment, and but there it's rejected. Finally, and I'm coming to the end, finally, I would like to mention two good counter-examples because we have them as well. Firstly, a judgment of the Frankfurt Higher Regional Court should be mentioned here, in which the previous decision of the Frankfurt Regional Court was overturned. This was the case Hendrik Bruder against I think it was Melzer against Hendrik Bruder. The Higher Regional Court overturned the Regional Court's decision on the grounds that the plaintiffs had deliberately gone public with, and I quote, his statements, the statements of Abraham Melzer, which in the eye of many were provocative, which is why he had to expect criticism that was also provocative from his point of view. And another counterexample is the Düsseldorf Regional Court in the case 2003 Carsley. And this in this decision is also included the aspect, or they also considered these aspects. And the interesting point is that both courts then come to the conclusion that the general right of privacy, allgemeine Persönlichkeit, must take a backseat. So one can here see that these examples that show that these criterions in particular can make a significant difference in the outcome of the legal disputes. I finally come to the conclusion. The analysis of the judgments in connection with allegations of anti-Semitism has shown that the intention of the Nuremberg Higher Regional Court in the case Naidu, quoted at the beginning, and you can see it again here, to enable an open discourse on hidden anti-Semitic tendencies is not achieved by the courts. On the contrary, the judicial discourse and the knowledge about anti-Semitism reproduced therein actually excludes the discussion of current manifestations of anti-Semitism. Anti-Semitic resentments are even relativized and normalized, while criticism of anti-Semitism is condemned by the courts. In order to make current manifestations of anti-Semitism visible and thus enable an open discourse on anti-Jewish resentment, in the present, a critical and reflective approach towards anti-Semitism, as well as a dogmatically stringent implementation of the balancing of interests, would help here. Even if this cannot completely rule out the influence of subjective values, critical reflexivity can at least raise awareness of one's own perspective, allowing one's own knowledge to be questioned. Above all, however, a fundamental long-term and continuous examination of the patterns and thus the grammar of anti-Semitism in the sense of Klaus Holz and Thomas Haury, they published a really, really good book on that, is also required. So we need knowledge about anti-Semitism. Such an engagement with anti-Semitism is imperative, both in legal scholarship in particular, and in society in general, because the two discourses are not independent of each other, as the study has shown. Thus, judicial decisions are always also a reflection of prevailing social values and views. Thanks a lot.
Thank you very much for you stay here. Thank you very much for your presentation. I think we can have a few questions in the room. I don't know whether there are any questions on the channel. So any questions here in the room on either factual aspects, doctrinal aspects, or perhaps sociological aspects? Who wants to pick up? Any volunteers? Yes, please go ahead and use the microphone, please. Yeah, lovely.
Okay, you showed how German courts deal with issues of anti-Semitism. Do you have any insights into what courts in other countries do, especially if it comes to anti-Semitism? I mean, you showed that the courts focus this German history or take this as a focal point for having this very strange way of dealing with in this decision. So how do other courts in other countries deal with these issues? Is there a similar pattern which is visible when it comes to approaching anti-Semitic speech? Or is this, again, showing this German particularity?
Thank you very much for that really, really good question. You are absolutely right. It would be really, really good to have a look, at least in Europe, to see in other countries, because here you can see the background, the so-called history of Germany plays an important role. But I have to admit, we have not looked into it right now. Nina Keller-Kemmerer is working on it. But I have no idea of her, what the outcome of her study is. So, but really, really good question. Thank you. It might be different because they don't have that. Yeah, perhaps it's that background, the history of Germany. Thank you.
I can perhaps add a few remarks because we have yet another project which deals with a comparative approach on anti-Semitism. And we are in the process of looking at French, British and Polish case law, and will hopefully, if we get funding for it, also expand it to Ukrainian case law. So the interesting aspects are probably threefold. First, it's very difficult to access court cases on these matters and to identify court cases. So the problem which we have in Germany, that courts have, it's challenging for courts to identify anti-Semitism, is a problem both for courts outside Germany, and it's a problem for addressing these issues. So there are, let's say, very limited numbers of case law, at least as far as we have come currently. So we haven't yet analyzed a lot of Polish case law, but a lot of British and French. And there is, compared to the German discourse, which we have now, it's still very limited, the number of cases. Second, so access to cases is a problem. The first. The second is that the identification of anti-Semitic behavior, the recognition of what is anti-Semitic. And the third one is that indeed the discourses are separate, are distinct. I think what is really interesting, and I appreciate what you said in particular with regard to the continuous reference to the Shoah. What courts have not really realized, what they haven't yet really seen, is that this is counterproductive in the sense that whereas in the past one might say, recognizing the immediate victims of Shoah is very important. And in the context of, for example, cases on free speech, we know that this has been an instrument, a tool to actually protect these victims. But the further we move in history, the more the same argument, which in the immediate post-war period could be used to protect the victims of the Shoah, is now turning against the victim of anti-Semitic activities. So what the court should realize, and I think that's what your research demonstrates, is that we have one and the same argument, which due to the context is changing in effect. Yeah? And that's what I find particularly challenging with what the courts are currently doing. It seems sometimes, I must say, if I may add this, for me, it sometimes seems so natural to simply see, oh, well, someone must be pretty blind just not to realize that this is an anti-Semitic statement. And sometimes I have the impression that by developing a legal argument around this, you lose the natural sight towards the whole issue, and you develop such a narrow, artificial perspective on anti-Semitism, which doesn't meet real-life cases. Sometimes we as, I think this is really interesting, that sometimes we as law teachers say that students have a pretty good judicial sense when they start their studies, and at the end of their studies, they've lost precisely that sense of ordinary judicial insights. And this is sometimes due to the fact that we may develop very good arguments in the first instance, but then we lose the possibility or the capacity to adapt these arguments to changing circumstances. It is pretty obvious that the further we move away from the Shoah, the less important, not the Shoah is as a historic event, but as an event which affects people immediately. So the anti-Semitic effects, I think they are just changing, and jurisprudence or case law should actually follow this. I think this is one of the challenges which we see there. Any further comments? Yes, please. Please use the mic. Yeah.
Thank you very much for this fascinating and a bit depressing presentation. You have presented the reduction of anti-Semitism to the Shoah as something that plays a role in weighting the impairment of the right to privacy. And I was wondering, I'm not sure whether it is important for your research or if you came across it, if the courts are narrowing down anti-Semitism when weighting the fundamental rights, do they also link it that close when they question themselves whether an argument or some speech is anti-Semitic, and then say, yeah, be anti-Semitic, it must also be National Socialist, which would make it very difficult to prove, and which would also narrow down the anti-Semitism too much. So my question is, does the implication goes further than just being important for the weighting of the impairment of the right to privacy.
May I repeat your question if I got you right? You mean if it's when it's vice versa? For example, if someone goes against the lyrics of Say When I Do, if it's the same with that?
No, it is rather when the court is asking himself or itself, is something anti-Semitic? So it looks at some speech and then asks the question, is it anti-Semitic? And does it then say, yeah, to be anti-Semitic, there must also be National Socialist thoughts in it?
I think yes, yeah. It's the fact I was talking about my colleague Greta Goebel, and she's looking exactly at that point. So that would be the decision, for example, if someone would sue against Say When I Do, and the court had to ask, okay, is that really anti-Semitism, and or is he allowed to sing such a song? I think yes, they have a narrow understanding of anti-Semitism in their, and yeah, the idea behind, and I think it's not only courts, it's the general, it's the general discourse. Okay, anti-Semitism stopped after World War II. So we have anti-Semitism only in connection with National Socialism and everything the other. So we don't go beyond that understanding of anti-Semitism. Yeah. And I would like to add something, because you talked about the judicial sense. I think the judicial sense here in those cases was you can't call somebody an anti-Semite in Germany. So that was the sense. And when you read the judgments, you really see, okay, they want to come to the point at the end that that's not allowed to call somebody an anti-Semite, only if one is really, really a Nazi. And I think it's a huge problem, because we need to discuss racism. We need to discuss anti-Semitism openly. So if somebody is acting or reproducing anti-Semitism or racism, we have to have the open discourse to discuss this. And the interesting thing is that the Higher Regional Court of Nuremberg, they really say it at the beginning. They want to open the discourse. But the point, had the idea of, okay, anti-Semitism is so terrible, we don't have it anymore here in Germany, you can't call somebody an anti-Semite. And that's the huge problem. So I think they have a judicial sense, but from my point of view, it's not the right judicial sense. So, and one can see it. They want to come to that point by writing that's why they repeat always the intensity of the Eingriff in das allgemeine Persönlichkeitsrecht.
If I may just follow up on this. Yes, I think it's the problem is that they focus on the reputation of the person who is accused of being an anti-Semite. Yeah, but they don't focus on anti-Semitism. So one of the problems from my perspective is that they are much more concerned with the reputation of people participating in a controversial discourse than they are concerned with actual anti-Semitic behavior. And this is a problem, because by focusing on reputation rather than on anti-Semitism, they lose sight of what is the cause of the discourse. That's my perception. And I'm wondering whether, it also plays a role on which of the rights they actually refer to. I'm very skeptic that the protection of privacy, the protection of the personality is the appropriate right to be inferred in this discourse, because it's all about discourse. So the whole discussion should be about different dimensions of freedom of speech. It's very different when we talk about the victims of anti-Semitism. That's what Nina Keller-Kemmerer is focusing upon. I think that's where personality rights or privacy rights are directly affected. I think the courts for whatever reason, have chosen, I would say, the wrong right, so to say, to balance. And the reason, it's interesting to find out more about the reasons of courts doing that. Probably it's an underlying, I don't know, a tendency which you described as whether it's right or left, it doesn't really matter, but it's a tendency to exclude a discourse about anti-Semitism rather than promoting a discourse about anti-Semitism. So if you wanted to do that, you would have to stay in the two sides of freedom of speech. But now that they've tried to move this to a different right, which is primarily concerned with the reputation of someone, they actually have the wrong perspective on this. Yeah, I think it's very difficult to catch the key legal issue, because this is about the scope of protection of the right. In German, we would say Schutzbereich. So probably it's less the description of facts, but it's simply the wrong selection of the human rights or the individual rights that are applicable to the case. That would be my question, what you think about this.
Thanks a lot. That's a really, really good question. And I have to admit, I'm not sure if I see it like you, because I think if the courts really take into account the balancing criteria and taking allgemeines Persönlichkeitsrecht and freedom of speech, that works actually, but they don't do it. And I think it's not about the question here if it's anti-Semitism or not. They can leave it out. The question is, do they have a Recht auf Gegenschlag? When is somebody allowed to react? It's really, really important, the Recht auf Gegenschlag. You don't even have to attack somebody directly, that he's allowed to counter speech. But it's like the speaker of the foundation of the Amadeo Antonio Stiftung. She was allowed for the Recht auf Gegenschlag, because Sevenadu, he entered into the discourse, public discourse, and he's allowed to do it. That's the other side. So it's one has to say that there are anti-Semitic resentments. They can be reproduced in public, such as racism as well. But we have to see that there's a right to counteract. That if somebody does it, yeah, he has to know that there is the possibility of reaction. And reaction that's not only, okay, that's not good, but harsh reaction. We can call him an anti-Semite. If that's true or not is not a question for the judgment for the courts, but it's a question which we have to discuss in the public discourse. And that public discourse is not opened here, and that's the really, really huge problem. I think more than the question is that APR, Allgemeines Persönlichkeitsrecht, or Article 3, I think it would work with those balancing criteria, and it's shocking really that they don't take this balancing criteria into account. And I think it looks like they have a judicial sense, and they want to come to that judicial sense. That's why they always repeat, okay, vor dem Hintergrund der deutschen Geschichte ist es so schlimm, jemanden Antisemiten zu nennen. That's what they repeat, really, not only twice, but 3 times.
In German procedural law, it's possible if judges are not experts on a certain question, they can hear an expert's opinion. They can hear a Sachverständiger to get an inside view on a certain topic. In these cases that you looked at, do the judges do that? Do they hear experts on anti-Semitism, or do they even pose the question if they need someone, an expert, to explain if something really is considered to be anti-Semitism?
That's a really, really good question. It's an important point. No, they don't.
they never do it concerning anti-Semitism or racial question. I think, yes, they should. They really should. If the question is really the question, if it's anti-Semitic. I think that in most cases, it's not about the question if that's anti-Semitic or not. But if it's, yes, they should. And we have one judgment. The Beklagte brought into an expert opinion, but the court said, okay, no, we won't take it into account. So no, they don't do it. But it's a good question. I think they really should.
I was wondering now if this some discourse, or are you rather skeptical? Because if I understood it right, it is less than there is bad faith with the courts, but maybe more some, yeah, they just don't get it or don't really understand it.
Yeah, that's a good question. I can't answer the last one. We don't know. I think it depends. It's always different. It depends from court to court, from case to case. I don't think that's always the same. We have, as we see, 2003, a decision concerning the Castley case. We don't know why they decided as they decided. We have no idea. My idea was, okay, perhaps the discourse came later. Der Diskurs mit Verzögerung ist in den gerichtlichen Diskurs hinein. So, but we don't know. So it might change. The other question, I think it will a little bit, I hope it will a little bit. We need knowledge, actually. And I think we are at the beginning to gaining knowledge, to have the translation of the Antisemitismus Forschung into the legal discourse, but we need that, yeah. And then I think then if we gain knowledge about it, there is the possibility that it's going to change, yeah.
Do we have any more questions? Yes, please. Yeah.
Could I talk like that? Yes, I just wanted to ask with the question of him. Now we see after the Israel-Palestine conflict that I'm someone who's affected from this war because yes, my family is from Palestine and I came here because it's very important to understand that this has nothing to do with their religion. But what I recognized is that in Germany, from a very young old, we start to see anti-Semitism in schools. And I just heard a lot of things like, I can't say that now, but what is so the German state is doing to fight anti-Semitism, if we can call it by this name? And this is my question: what can we do to begin at a very young age to say, children, that's not good what you're saying? And I just wanted to ask them, because we have this issue, and this issue is not, in my opinion, not linked to our history. Okay, it's linked to our history, but it's not only coming from there, because it's in all classes. It's in German and on Muslims, and everywhere I looked, I saw anti-Semitism. And that's my question: what can we do, or what should law do at a very young age?
That's a really, really good question. And you're absolutely right. We find hatred against Jews in all of that's why I took again this slide. And I think we ignored that. So I think the majority still believes we overcame anti-Semitism after World War II. So those people were not affected. That, for example, that's why Documenta shocked us, because us means, for me, I'm a non-Jewish person who's not affected. But I think I'm not sure if law is the ultimate method to fight it. Yes, we need to fight it also with law, but I think we have to start. And I think, yeah, we can use that. We need the discourse. We need to debate it. We need to discuss it. So yeah, we can use law, and especially those judgments I just analyzed, because they cut the discourse, but we need the discourse. So I think it needs to start in the society, in the public discourse, and yeah. Yeah, thank you it's a good question. I don't have a solution.
Thank you.
Yeah, thank you very much for the questions, for the answers, for the discussion, for coming here. I think we'll conclude our lecture here for today. I would like to invite everybody to a virtual, so online only, panel next week. It will be on the transformation of violence in Colombia. We will have a panel discussion, which includes, among others, Sabine Kurtenbach from GIGA in Hamburg, and the Colombian ambassador to Germany from Berlin. So it will be a panel which looks into the transformation of violence in the context of the Colombian conflict, in particular, violence committed by non-state actors. So this should be an interesting conclusion for this semester's lecture series. Thank you very much once again for your class, and we'll conclude. Thank you.
Thank you.